We're going to look now at the new powers to vary or discharge title conditions under the statutory provisions of the 2003 Act. Section 90 has powers of the Lands Tribunal as respects title conditions. Now, I'm hoping you'll be sent copies of the sections with notes of this if you apply for these, and it will make more sense. So if I can just read from the section, it says, subject to other sections of this Act, the Lands Tribunal may, by order on the application of an owner of a burdened property or any other person against whom a title condition or purported title condition is enforceable, to discharge it, vary it in relation to that property, or if the title condition is a real burden or a rule of a development management scheme, it can determine any question as to validity, applicability, or enforceability, or as to how it is to be construed. Also, an owner of a benefited property can renew or vary in relation to that property a title condition which is a real burden in respect of which intimation of a proposal to execute and register a notice of termination has been given under Section 21 of the Act, or a real burden or servitude affected by a proposal to register a conveyance, being a proposal of which notice has been given under Section 107(4) of the Act. Section 97, there's power regarding granting unopposed applications for discharge or renewal of real burdens. Subject to subsection below, an unopposed application duly made for discharge or variation, or for the renewal or variation, or the preservation of a real burden, shall be granted as of right, and as respects an application under paragraph A, which is discharge or variation, neither subsection 6A or subsection 8 of the section 890 of the Act will apply in relation to the order discharging, or as the case may be, varying the real burden. Now, subsection 1 does not apply as respects an application for the discharge or variation of a facility burden or of a service burden, or under section 91(1) of the Act for the discharge or variation of a community burden imposed on any unit of a sheltered or retirement housing development. Section 98 deals with granting of other applications for variation, discharge, renewal or preservation of title conditions. In other words, ones where it is opposed, and an application for the variation, discharge, renewal or preservation of a title condition shall, unless it falls to be granted as of right, will be granted by the Lands Tribunal only if they are satisfied having regard to the factors set out in section 100 of the Act. So there are various factors set out there, but there are some exceptions here. Except in the case of an application for a deed of variation or discharge by the owner of an adjacent unit, it has to be reasonable to grant the application, or in such a case the variation or discharge in question is not in the best interests of all the owners taken as a group of the units of the community, or is unfairly prejudicial to one or more of those owners. So there are substantial powers here to vary and discharge. The factors are important. The factors are all important when you're dealing with cases of this nature. And these are set out at very great length, the factors to which the Lands Tribunal are to have regard in determining applications. And the factors are: A, any change in circumstances since the title condition was created, including, without prejudice to that generality, any change in the character of the benefited property, of the burdened property, or of the neighbourhood of the properties. B, the extent to which the condition 1 confers benefit on the benefited property, or 2, where there is no benefited property, confers benefit on the public. C, the extent to which the condition impedes enjoyment of the burdened property. D, if the condition is an obligation to do something, how practical or costly it is to comply with the condition. E, the length of time which has elapsed since the condition was created. F, the purpose of the title condition. G, whether in relation to the burden property there is consent or deemed consent of a planning authority or the consent of some other regulatory authority for a use which the condition prevents. I tried to think of what that might be. So you're talking about obviously planning department of the council, but also if I would imagine you have a grant of a license for selling alcohol, that would be something that could be taken into account by them too. H, whether the owner of burden property is willing to pay compensation. If the application is under section 90 of the Act, the purpose for which the land is being acquired by the person proposing to register the conveyance. And J, any other factor which the Lands Tribunal consider to be material. So you will see that there are a lot of factors that can be taken into account, and there's a general sweep up there that anything else which the Lands Tribunal consider to be material can be relied upon as well. So that's just a snapshot of the various powers that are there. What I want to go on to do next in the second section of this, part 2, will be the making of an application and how you deal with it. And I would just like to say at this stage, or we'll come back to it, this stuff is the stuff that conveyancers should be doing day in, day out. Please don't duck it. These are things that you know about. It's not very detailed here. It's not overly court orientated, the whole procedure. It can be done fairly simply, but the main principles of it are the ones where you will have looked at the Act and worked out whether you think your case might work, might be possible to vary a title condition or defend it not being varied, etc. So you will be able to make those decisions, and it's stuff that you really do know, and that should be your input. Because the procedure is pretty easy later on, I do believe that a lot of practitioners could do most of it themselves. They might want to, if a hearing is required, give that to their court department to deal with, or a court practitioner to do that part of it, but you understand the law, and I think that you're quite capable of doing all of this. I wish I'd stumbled upon all of this a lot earlier in my career and had a case or two to get early into, but I didn't get that chance until the very last minute, so I became a bit of an expert at the very last minute. Anyway, all I'm saying to you is I think you should continue with us into part 2 when we're making the application and going through what's required in the various stages, and we can then take it further and let you see just exactly what's involved. Thank you very much.